Hi, guys. Hello. I think that it's working now. I don't know what was wrong with it. Let me know if you guys can hear me okay. Happy October, Sherry. Yes, it's October the 1st. It is October the 1st, and I'm so excited. Yay. You guys let me know if you can hear me, though, okay? Please. And thank you. Please and thank you. Ooh, mums and pumpkins. I love mums and pumpkins. Okay, Michelle hears. Good deal. Good deal. Yay. All right, I got my coffee. It was only 4 minutes until like go time, or 4 minutes until noon time when I can have my coffee. So I went ahead and made it my coffee with the creamer. I've had black coffee since 5:30 this morning, but anyway. So I want to say I'm so sorry. If I made anyone worry Friday or Monday, I did not intend to. Friday I had a doctor's appointment. Kiddo had a doctor's appointment, so we were both at the doctor's office, and it was just checkups, nothing wrong, just follow-ups and that kind of thing. But anyway, yeah, it was a late appointment, and we had crazy wind. They called school off on Friday because of the weather from the hurricane, and the wind was insanity. It was so windy, like blowing my umbrella out of my hand windy, right? But anyway, so that was Friday. And by the way, you guys, I got prescribed a blood pressure pill. So I'm adding that to the list. Then on Monday, yesterday, I woke up yesterday morning and I had this and I still do. It's not as bad today as it was yesterday, but it's still pretty out there. Like insane sinus pressure that is like mostly affecting my left side, and it like hurts everything outside and inside on that side. Like I have like my jaws hurt, my ear hurts, my teeth on that side hurt, and it's just feels awful. So yesterday I was like, no, I didn't feel like doing anything. So but yeah, that's why. And I didn't mean to make anybody worry. I saw that Donnie or Donnie in the chat, which I don't know. I haven't seen her yet. So I don't know if she's here. But Donnie had commented on something and said something like wanting to make sure everything was okay, and I was like, I guess I better say something, huh? But anyway. Michelle, I know. Oh my gosh. It's so scary. North Carolina, parts of North Carolina. I mean, I don't know how much of North Carolina, but I know, was it Asheville? Places around there just got destroyed. Sherry said the wind blew off 2 pieces of siding from our garage. Yeah. Hey, Brenda. Hey. I guess I need to say hi to everybody. I missed you guys over the weekend and missed you guys yesterday. Let me go up here. Oh, Michelle says, hey, Jenny tagged you in a video Lori Vallow's son did this week. Let me know if I need to type it in the chat. I follow his channel. Yeah, I need to go check that out. What was it about? Good morning, Miss King and Henny, Brenda, Sherry. Good morning, sweet Kale. Kale said she was working and lurking. Good morning, Steph. Thank you for posting the stuffs. Thank you for posting the stuffs. I appreciate it. La 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 la. Happy October the 1st. Michelle, though, talking about the mums and the pumpkins, that makes me, ooh, I love that. If I missed anybody, I'm sorry. Oh, hey, Ween Baby. Biltmore House. Wow. All the mountains down to Davison County. Oh. Colby did a replay of what Lori read at sentencing and reacted for the first time. Oh, my God. Patricia says, if you don't, hey, Patricia, she says, if you don't love me at my frog logs, you don't deserve me at my cafe talk. That's so cute. Oh, you guys, I was fiddling around. So, I did the other stream last week with OBS, and I like OBS. And I'm not giving up on it. I just need to figure out the little things. Because, like with StreamYard, I can turn my camera off like that. And you guys know I'm still here, right? But like with OBS, I haven't figured out how to fix that. Because if I wanted to shut my camera off, it makes my whole thing go away. And so it looks like I'm not even there. But other things like being able to show the comments on the screen, like this one, Oh, that's sweet, Brenda. That's sweet. I appreciate you. And just other things like being able to do this right here, like right? I mean, I can do those things or like this. Like if I want to do this. Yeah, I can do those things, just not as easy as I can here. Cuz there you have to like build it all in. So, I don't know. And then I have my sound clips and all that kind of stuff. But anyway. All right. We've been yakking for 10 minutes almost. We're going to get to this trial. Oh, but before we do, what I was going to say is I have a green screen behind me. And so the white door with the yellow caution tape is not real. Just so you know. But if I turn it off, look. Here, hold on, let me look. Right? It's a green screen. Actually, let me tell you guys something. I bought a green screen fabric from Amazon, and it doesn't work nearly as well as what I'm using right now. Back there, what I have is dirt cheap green neon poster board. It's like $1.44 at Walmart, a big sheet. So I bought a few sheets and taped it all up on my little white gray panel back there that I keep back there. And yeah, you can see part of my panel right here. I didn't get enough poster board, and like right there behind my chair. But anyway, Walmart for the win, right? Hey, Margaret, love you. You, Miss Ma'am, need to be in the bed. You need to be in the bed getting some rest. But, here, let me show you let me go. Do you like the crime scene tape one? Or do you like the brick wall? Or do you like the gray? Or the black? Or this one. Looks like I have a pretty rock fireplace behind me. You guys tell me which one you like, and I'll use it for today. But as far as this trial goes, I don't have any gray crime scene tape. Patricia likes the crime scene tape. Ween Baby said crime scene tape. Brenda said crime. Okay. Crime scene tape it is. There we go. Sorry, Michelle. You got outvoted, ma'am. You too, Miss King. Sorry. Michelle said, as long as your face is there, we don't care. All right. So as far as this trial that we have starting today, I know nothing about it. Steph had asked earlier for like a backstory, and I'm like, I don't really have a backstory. I didn't know anything about it until I saw it pop up on my newsfeed earlier today on YouTube, and I was like, And then I saw the words pro se, and my ears perked up a little bit. I was like, pro se, you say? So then I had to click over and read what it was about and kind of watch it, and I was like, ooh, this might be good. All I know is that the guy that is on trial, his name is Quentin Nixon, and he is on trial for the murder of the gal. Her name is Taylor, I think. Brenda said pro se, and that was like, what? So he murdered this gal, and he's his own defense attorney. He's lawyering himself. So anyway, we're gonna get into it and see how this goes. I just love a good pro se, right? Love a good pro se. So, thank you, Spins. I appreciate it. You're awesome sauce. Yeah, our QB is out today. So, Spins and Steph are doing all of the moderatey things. Thank you, girls. I appreciate it. Man, I'm going to have to go take some ibuprofen. So, it feels like I was telling somebody yesterday, it feels like the pressure is like wrapped around my jawbone, and when I like move my jaw around, it pops and cracks, a lot. Oh, Morgana, hey, I didn't see you say anything about, did you say something and I missed it? I'm sorry. I'm sorry. You're not chopped liver. You're not chopped liver, ma'am. All right, let's get started. Let's get started. Fast forwarded it to right whenever they bring him in. So let's go. Kel, thank you. Thank you. Thank you, Margaret. Thank you, Morgana. You guys crack me up. Thank you, Spins and Steph. All right. The camera's moving, and there's the defendant. Pro se.
All right, so just so you know, the first two witnesses do not want to be videotaped. You can, clearly play their audio, but no, put it on something on the wall. Please, thank you.
I do have Kel, or Spins. You're right. I have the best mods ever.
Your Honor, this is the State of Ohio versus Quentin Nixon. We are here on two cases. Case numbers 2022-06-2276 and 2022-09-3102. Mr. Nixon is present with standby counsel Joe Perry for the defense for the state.
Ooh, Joe Perry. Yeah, that's another thing, Miss King, I forgot to mention too. This is a bench trial. This is not a jury trial. So the difference in a jury trial and a bench trial is jury trials are just that. That's the majority of the trials we watch are jury trials. They have a jury with jurors. But with a bench trial, there is no jury. It's the judge who hears the evidence and makes the hands down the verdict. So, all right.
Assistant Prosecuting Attorney Felicia Easter and Jeremy Villette.
Thank you very much. All right, so we are, it's 9:20. We're proceeding with trial. There are some motions that were filed late last week that the court is going to address before we get started. All the previous orders that I have either granted or found or held in abeyance, I will rule after hearing the testimony. So first we have the motion to dismiss filed by Mr. Nixon on September 20th for motion to dismiss based on vindictive prosecution. Go ahead, Mr. Nixon.
Exactly, Kel. Good point.
One moment, Your Honor.
Sure.
Then again, it could take all 10 years longer.
Your Honor, that motion was filed by me based on several of my rights have been violated since the beginning of this court proceeding.
Yes, Spins.
Endeavor.
Yep.
I did not have a preliminary hearing. I wasn't afforded a lawyer at the proper time, at the most critical stage in the case. And a lot of my rights were being waived without my knowledge.
Yes, Morgana. They have a hearing today at 1 o'clock. Or not a hearing. What is it that they're having today for him? It starts at 1 o'clock. Some kind of a hearing. I can't remember. Michelle. Subject matter jurisdiction grounds. Every time I think of a pro se defendant, I always think of Daryl Brooks. Every single time. Me either, Spins. Me either. Flashbacks, right? Let's see. I wanted to see what was the ba-ba-bum. Preliminary hearing. Okay. Good deal. Yeah. So yeah, I kind of wanted to maybe take a peek at that. I don't know. But so Spins pro se, I don't know what the actual what the Latin, because it's apparently Latin, but I don't know what the actual terminology means, what the definition is, but when they represent themselves, that means they're pro se. Let's Google real quick though what the actual definition. On one's behalf, to represent oneself in a legal proceeding. Origin first known use in law was 1861, Latin, on one's own behalf. So. For oneself, yeah. I mean, everything legal stems from something Latin. I mean, of course, every word pretty much kind of does, but you know what I mean. All right, let's continue on. Definitely Morgana, like the Kentucky, the sheriff. I shot the sheriff. No, it would be I shot the judge, right? But I don't know, but I'm hoping that we might get some sort of motive today, because that's the only thing. Everybody's speculating what the motive was, but we don't really know the truth of the matter. So anyway, I would like to see it. So yeah.
Donald Malarsic was my lawyer at the time of the case.
Yeah, he
when the
did
case
resign.
Started, I believe his excuse was he was sick, I believe. Well, I had 2 arraignments I wasn't present for in municipal court, and a grand jury hearing I wasn't present for or notified of, as well as my preliminary hearing. And me denied those rights have prejudiced and affected my case in a very negative way. Had I would have been afforded a preliminary hearing or being allowed to testify at the grand jury hearing as a witness, because technically I'm still innocent, I believe my case would have moved forward in a different direction. And a lot of things that have to be clarified now would have been clarified in the beginning. I'm entitled to a right of competent. At the time, I was entitled to a right competent lawyer. And yeah, him not being there violated my rights as well. So that's what that motion was based on.
All right, thank you. Ms. Easter, anything on behalf of the state?
Thank you, Your Honor. The state will respond. The defendant's claim to the motion as titled, the state does not believe are on point or pertinent to the vindictive prosecution. The defendant is arguing procedural matters that have been argued throughout the course of this case that the court has already ruled on. As for the motion itself, he cites general state and U.S. constitutional law. It's not stated with specificity regarding vindictive prosecution. I actually have not been privy to vindictive. I would align this in terms of a motion he already filed and has been denied by the court, which is selective or malicious prosecution. I will not state those grounds again, but we argued that as stated in previous motion hearings, Your Honor.
Thank you. So it does seem as if this motion is cloaked in arguments of all previous motions that the court has ruled on with regards to the preliminary hearing. There was an indictment process that superseded that preliminary hearing process. As for the grand jury, I've already previously ruled on that issue, and with regards to Mr. Nixon indicating that he was denied the ability to testify. There was never a request to testify, and therefore there was no denial of him to testify at the grand jury. And therefore, the motion to dismiss based on vindictive prosecution is denied. The next is Mr. Nixon's motion with response to medical records. I've read your motion, Mr. Nixon, and without any additional arguments, those records were ordered by the court based on arguments that you made during the motion to suppress, and based on that ruling that I've ruled on.
You guys, look what Morgana just sent. She said this is the face Jenny made when my screen froze. Look. You kill me. You kill me. Kill me, kill me, kill me. Hold on a minute. Wait a minute. Wait. Okay, Spence was the one that said it. The judge is thought to have done that, or the sheriff, talking about the other case, the Kentucky case. So I'm not really positive, but I think, like, you've got some people who say the sheriff knew stuff was going on, but things were happening in the judge's chambers because there was no camera. I don't know. That's why it's pure speculation. And I want to wait for the motive so I can, because I don't want to be out here saying stuff when I don't know what happened. You know what I mean? So, but anyway, all right, let's go back.
That motion is denied. The next is the motion to dismiss felony charges for delay of preliminary hearing. Go ahead, Mr. Nixon.
Okay, Your Honor, so my indictment says direct indictment. This is a murder case. My charges cannot be direct indicted. And I was in Summit County's custody at the time. And it was said that my lawyer waived my right to a preliminary hearing.
This guy is really just going to piecemeal this whole thing together, isn't he? Jeez.
Is that it?
No, Your Honor. Notwithstanding any provisions to the contrary in Criminal Rule 5B, shall be accorded a preliminary hearing within 15 consecutive days after the person's arrest. If the accused is not held in jail in lieu of bail or on pending charge, or within 10 consecutive days after the person's arrest, if the accused is held in jail in lieu of bail on the pending charge, except as provided in Division C of Section 2945.73 of the revised code, shall be brought to trial within 270 days after the person's arrest. Being that I have two charges, that is what I fall up under. Discharge for delay in trial. A charge of felony shall be dismissed if the accused is not accorded a preliminary hearing within the time required by sections 2945.71, 2945.72 of the revised code. Such a dismissal has the same effect as a nolle prosequi. Upon motion made at or prior to the commencement of trial, a person charged with a misdemeanor shall be discharged if the person is not brought to trial within the time required by the sections 2945.71 and 2945.72 of the revised code. Such discharge is a bar to any further criminal proceedings against the person based on the same conduct, regardless of whether a longer time limit may be provided by the section 2945.71 and 2945.72 of the revised code. A person charged with a misdemeanor shall be discharged if the person is held in jail in lieu of bond awaiting trial and the pending charge for a total period equal to the maximum term of imprisonment which may be imposed for the most serious misdemeanor charge. For a total period equal to the term of imprisonment allowed in lieu of payment of the maximum fine which may be imposed for most serious misdemeanor charge within the offense or offenses charged constitute minor misdemeanors. A discharge under B2 of this section is a bar to any further criminal proceedings against a person based on the same conduct. A person charged with a felony who is not brought to trial within the time by sections 2945.71 and 2945.72 of the revised code is eligible for release from detention. The court may release the person from any detention in connection with charges pending trial and may impose any terms or conditions on the same release that the court considers appropriate. C2, upon the motion made at or before commencement of trial, but not sooner than 14 days before the day of the person would be eligible for release pursuant to Division C1 of this section, the charges shall be dismissed with prejudice unless the person is brought to trial on those charges within 14 days after the motion is filed and served on the prosecuting attorney. If no motion is filed, the charge shall be dismissed. The prejudice unless the person is brought to trial on those charges within 14 days after it is determined by the court that the time for trial required by the sections 2945.71 and 2945.72 of the revised code has expired. If it is determined by the court that the time for trial required by sections 2945.71 and 2945.72 of the revised code has expired, no additional charges arising from the same facts of circumstances or its original charges may be added during the 14-day specified under this division. The 14-day period specified under this division may be extended at the request of the accused or on the account of the fault of misconduct of the accused. Preliminary hearings in cases In the felony cases, the defendant is entitled to a preliminary hearing unless waived in writing. Your Honor, they do not have my handwritten signature in writing. Not one lawyer has my signature in writing that I waive my preliminary hearing. If the defendant waives his preliminary hearing, the judge or magistrate shall forthwith order the defendant bond over to the court of common pleas, except upon good cause shown. Any misdemeanor other than a minor misdemeanor arising from the same act or transaction involving a felony shall be bonded over or transferred with a felony case. If the defendant does not waive the preliminary hearing, the judge or magistrate shall schedule a preliminary hearing. I repeat, if the defendant does not waive a preliminary hearing, the judge or magistrate shall schedule a preliminary hearing within a reasonable time. There was not a preliminary hearing scheduled. But in any event, no later than 10 consecutive days following or service of the summons, if the defendant is in custody, and not later than 15 consecutive days, arrest or service of summons. If the defendant is not in custody, the preliminary hearing shall not be held. However, if the defendant is indicted. I was indicted, but I was in custody. I still should have been afforded my preliminary hearing.
All right, anything on behalf of the state of Ohio?
Excuse me, Your Honor, the state argues again that this issue has already been litigated in previous hearings. You actually just talked about it in the previous motion. The defendant, Mr. Nixon, just read in his last line, if there's a indictment held, that is sufficient. There was an indictment with the grand jury process in a timely manner, Your Honor.
Thank you. So again, I've addressed this issue in numerous motions already filed by the defendant or Mr. Nixon addressing the preliminary hearing issue. I will address it again and then rule on this motion. The state or Summit County's indictment process is what is referred to as a direct indictment process instead of or in lieu of a preliminary hearing. The evidence is submitted to the grand jury for their determination. This grand jury issued a true bill, and therefore Mr. Malarsik's waiver of the prelim at the Akron Municipal Arraignment, it was appropriate. What Mr. Nixon is referring to is when there is not a direct indictment process and the defendant consents to a direct bind over and waiver of the grand or preliminary hearing process. And therefore, these issues, A, are moot because the grand jury did hear evidence and did return an indictment, a true bill, outlining the charges. And so therefore, this motion is denied. The last and final motion is the motion for a continuance.
He didn't get his, he didn't get his wish. Hey, Shellbell, good to see you. How are you? Steph over here voting for crime scene tape. Like, I love when she does that. She cracks me up. Wayne Baby says this guy's jailhouse library lawyer isn't helping him at all.
Of the trial that I believe was filed, I don't see its timestamp, but late last week. Go ahead, Mr. Nixon.
Yes, Your Honor. I would like to put on record that a direct indictment is also known as information or direct filing. It is a legal process in which prosecutor initiates criminal charges against an individual without involving a grand jury. Instead of presenting evidence and seeking an indictment from a grand jury, the prosecutor files a formal charging document called information directly with the court. Direct indictments are typically utilized for less serious offenses or cases where the evidence is clear and involving a grand jury.
Are you arguing your motion to continue? Or are you arguing the motion I've just ruled on?
I'm not
Because if you're
arguing.
arguing the motion that I've just ruled on, you're going to move on and we're going to address your motion to continue.
I have a right to be heard, Your Honor. I'm not
I
arguing.
have heard you. I have read your motion and I've now ruled. So
I'm
we're
not
moving on
arguing
to,
anything.
we're moving on to the next motion.
Your
Do
Honor,
you
I'm
want
not-
to make any arguments to this court on the motion to
Your Honor, I'm not
continue?
arguing anything. I'm putting something on record.
Your motion's on record, everything you've read is on record. We're moving on your motion to continue. Do you want to address those issues in that motion, or do you want me to just rule? So here's your opportunity.
Yes, ma'am. That motion to continue was put in due to the fact that I still do not have all discoverable evidence. It was brought to my attention that the victim vehicle was on scene, and I don't have the tow inventory sheet or what was found in that vehicle. As well as the SWAT's narrative. I have a list of SWAT names, but I don't have the actual officers that breached the home.
See, okay. Kel says, Bev, take 2. So, okay, here's. So here's the thing. Kel, I don't think Morgana did, but Kel, did you watch Daryl Brooks' trial at all? I can't remember. Because she's pretty much like Jennifer Doro, Judge Jennifer Doro, take 2. And this guy is acting very well. I'm not going to say acting because I've only seen him for just a few minutes, right? But he is very much giving me Daryl Brooks. Yes, Daryl Brooks, Michelle, right? You did, Kel? Okay. Are you getting... It was the same with the Treehouse... Okay, I can't say that because the Treehouse Murder guy, the Tucker, I don't know. You could tell he did his homework, but whereas like with Daryl Brooks, he just wanted to argue. And so I don't know which way this guy is leaning, but I want to see if he gets like fed up and argumentative. If he says grounds one time, Shell Bell, I will. I don't even know what I would do, but I'll do something because that would be epic. I would totally lose my mind if he says grounds. Hey, Donnie. Tucker was smart. The judge was mean. I like the judge in the Treehouse Murder trial, though. But I know, Kel, I need to see more, too, because I can't make a decision yet. But just now, the kind of the way he was, like, saying, I'm not arguing, blah, blah, blah. I'm not arguing for that or that, whatever. That kind of gave me, like, a smidge Daryl Brooks. And she seems like a not so nice Jennifer Doro, because Jennifer Doro is an angel with the patience of Job. Just saying. But anyway. Patricia said, I think I would fall out of my chair. Me too. Me too. Donnie, I'm actually feeling better today than I did yesterday. I'm not going to lie. Everything on this side, this is my left side. I don't know if it's backwards for you guys in the camera, but this side doesn't. It's got some, but this side over here hurts. Yeah. I'm going to have to take some ibuprofen soon, I can tell. Because it feels very... Eesh. Ms. King says, I don't think the treehouse judge was neutral like he should have been. You're right. I kind of feel like he wasn't either, but I still liked him. But I liked him on his personality because he was very like, I mean, he sighed a lot. You could tell he had no poker face at all whatsoever. Judge Doro has beautiful hair. She has beautiful everything. I love her so much. All right.
So I can't cross-examine them if I don't have their name and badge number. I have a rough draft or a summary of what they're saying happened, but I don't know who are the physical officers that breached the home at the time of my arrest. So I put that motion in to ask for a continuance of the trial date because we're moving forward and I don't have all the evidence.
Anything else?
Nope.
All right. So in your motion, it also talks about the SWAT video, which I think has been established on the record, that the SWAT team does not wear body worn camera with regards to what he has just argued. Ms. Easter?
Thank you, Your Honor. Your Honor, the state has turned over all the evidence that we have. We have inquired to SWAT, to APD, and the detective is sitting with me as to all the evidence. I've turned over everything that we have. The specific statement about Tony Westover's vehicle that was on scene, Mr. Nixon was in court yesterday. He did ask me that same question. I did let him know that there is no tow report because her car was not towed.
Yes,
Since it
Donnie.
was the
That one
victim's,
was
her
in
family was
Florida.
notified, and they came and recovered the vehicle.
Yeah, we call it the treehouse trial, but it was in Florida, and it was some sort of like treehouse or the top of a trailer that was around a tree or something. I don't know. But anyway, it was basically a woman lived there. She like paid rent to the guy that owned the place, but I kind of feel like she was kind of like homeless. She's since passed. God love her heart. Her name was Paula. Oh, God love her. But that trial, yes.
All right. So I am satisfied, and the court has taken painstaking efforts to give Mr. Nixon the opportunity to be brought over to court to review all the discovery. I have, every time he has asked for something that he says he doesn't have or didn't receive, I have required the state of Ohio to either indicate to the court whether it exists or doesn't exist. I am satisfied that the state is in compliance with Rule 16, and therefore the motion to continue is denied. We are ready to proceed. On behalf of the state. No, that was a question. Are you?
Oh, yes, Your Honor,
All
thank
right.
you.
Mr. Nixon, are you ready?
Oh, there are a couple
Yeah,
preliminary.
hold on. First I need to get his answer on the record. Mr. Nixon, are you ready to proceed?
Your Honor, I would ask the court for oral motion to separate the witnesses. I don't want,
That's all you need to say.
Okay.
I know exactly where you're going. And I am ordering that anyone in the courtroom that is going to testify may not remain in the courtroom until their testimony is completed, with the exception of Detective Hornacek, who the state is permitted to have a representative sit with them at trial. So he is permitted to remain. Anyone else? And I'll make sure that the state of Ohio monitors who enters the courtroom to make sure that none of their witnesses enter the courtroom before they testify. The rule also applies to you. So I don't know if you have anybody that you plan on calling to testify, or anyone so you have to monitor too if you have witnesses subpoenaed, that they're not in the courtroom before they testify. Once they're done testifying, they can remain.
Yes, Your Honor. I'm ready to proceed.
Thank you. Ms. Easter, what are your preliminary motions?
Your Honor, at this time, in case number 2022-093102, the state moves to dismiss count 4 of the indictment. That count 4 is having weapons under disability, a felony of 3rd degree. Also, Your Honor, just for the record, since it's the day of trial, I know the court inquired of the defendant on the clothes he would like to be brought over in. The court gave the defendant on the record the option of street clothes or the jumpsuit that he currently is in. Mr. Nixon opted for the jumpsuit. This is a trial to the court. The court is able to discern the two with no prejudice or bias involved.
Thank you. All right, Mr. Nixon, they are moving to dismiss count 4, which is the weapons under disability. And based on that motion, I'm assuming you have no objection.
No, Your Honor.
All right, count 4 is dismissed. And then, Mr. Nixon, again, I'll inquire. The last time we were in court having hearings, I did inform you that you were able to wear street clothes if you chose to, or remain in your orange jumpsuit. At that time, you indicated that you were fine with wearing an orange jumpsuit. Is that correct?
Yes, Your Honor.
Okay, all right. I am satisfied then that Mr. Nixon understands what his options were and the fact that it is a trial to the court. Him being in a jail uniform has zero effect on this court, as the court is well aware that Mr. Nixon has been in custody since his arrest. All right, Ms. Easter, you may begin with opening statements. You may.
All right. Your Honor, we are here to hold the defendant, Mr. Nixon, responsible for the actions he chose to take. We are here to hold him accountable for what he did on June 5th, 2022, and July 2nd, 2022. The state will prove beyond a reasonable doubt that the defendant, Mr. Nixon, committed the crimes of improperly handling a firearm in a motor vehicle, murder with a firearm specification, and there are 2 counts, felonious assault with a firearm specification, and tampering with evidence, and that these acts were not committed in self-defense. Before I get into what happened and who all was involved, I want to take a minute to talk about self-defense, Your Honor. Self-defense, as the court knows, is the defendant saying, I did it. It was me. I did it. I just had a legal justification for doing it. Your Honor, self-defense is when the defendant was not at fault in creating a situation giving rise to the affray, and the defendant had reasonable grounds to believe that he was in imminent, immediate danger of death or great bodily harm. And the defendant had an honest belief, even if mistaken, that he was in imminent, immediate danger of death or great bodily harm. And the defendant was in a place he had a legal right to be. And I know the court realized I emphasized the word and. All of those, as the court is aware, must be present for the affirmative defense of self-defense. The state will prove beyond a reasonable doubt, as stated, this was not self-defense. So the state will prove beyond a reasonable doubt that the defendant was at fault in creating the situation giving rise to the affray. Or, that may be a 2-letter word, but it is very important, or the defendant did not have reasonable grounds to believe that he was in imminent, immediate danger of death or great bodily harm. Or the defendant did not have an honest belief, even if mistaken, that he was in imminent danger of death or great bodily harm. And lastly, or the defendant was not in a place he had a legal right to be. And again, I stress that word or, because the state has to prove beyond a reasonable doubt just one of those criteria, just one, and the affirmative defense fails. And if that affirmative defense fails, you're left with, I did it. It was me. with no legal justification. Now, what happened and who all was involved? On June 22nd, 2022, Your Honor, at 809 Kenmore Boulevard, multiple 911 calls were received regarding shots fired. The callers gave a description of the suspect vehicle. When the officers arrived on scene, they saw the defendant driving a vehicle that matched. Once the defendant stopped and the officers approached the car, they saw an AK-47 on the driver's seat. More ammo was found in and about the car. The defendant was arrested and he was Mirandized, Your Honor. Under Miranda, he said, people are messing with him. He thought people were pulling up on him. However, he also admitted to firing multiple rounds in the air and that he bought the rifle from a guy off the streets and carries it for protection. Your Honor, you will hear these 911 calls and see the firearm that the officers found on the driver's seat. Now, what happened on July 25th, 2022, and who all was involved? Well, it was at 2260 Maryland Avenue. Who all was involved was Angel McClain and Ronald Crew. They were both living at 2260 Maryland Avenue. It was actually Angel McClain's apartment that Ron Crew had been staying with her, living with her for quite a while. You also have Adam Wright, Ashley Broughton, and the defendant, Quentin Nixon. They all had been staying there visiting between 1 and 3 weeks or so as well. Finally, you have Brian Fielders and Tony Westover. They had come over that day, July 25th, 2022, to visit. Now, you have about 7 people in this tiny apartment, and I believe I call it in the house. It's an apartment, Your Honor. In this apartment, small apartment. Everyone was doing drugs. Their drug of choice was meth. They were doing it multiple times a day for multiple days prior. Everyone was getting high, feeling the effects of getting high. They were enjoying themselves. They were all getting along and having a good time. There was no arguing, no fussing, no fighting, Your Honor. The defendant was high, and due to lack of sleep and the effects of the drugs, and thinking Tony was the police, he grabbed Tony's gun. Now, how did he know about this gun? They were in the living room, Your Honor. Tony needed something out of her purse. That gun, she emptied the contents on the table, and there was the gun. After he grabbed that gun out her purse, a tussle ensued. Tony tried to get her gun back. He pinned Tony up against the door, the wall by the door, by her hair and neck, and he shot her, Your Honor. Again, prior to this happening, everyone was getting along. Everyone was no arguing, no fighting, no fussing. Now, he shoots Tony on the base of the neck and the arm. Brian Fielders and Adam, who was out there in the living room kitchen area, tried to help because the defendant was waving the gun, pointing at everybody. They tried to help. Brian Fielders tried to wrestle him and even bit his lip and bit the defendant on the cheek, on the face. And he'll testify to that. Adam, who had his own weapon, pulled his own weapon and tried to stop the defendant. Evidence and testimony will show the other individuals I named in this small apartment were in the back bedrooms, Your Honor, at this time. They will testify that when they heard the ruckus and the noise, they came out and looked. They will testify they saw the defendant have Tony pinned up against the door area, the wall by her head with a gun close to her, pointing it at her. And as soon as they fled back into the rooms, they heard the shots. They heard the shots go off that killed Tony. Now, once this happened, everybody, again, smoking, a lot of individuals had warrants, they decided to flee. They jumped off the balcony that is connected to Ron Cruz's room. As the defendant fled the scene, Your Honor, he took Tony Westover's gun and her purse, dropping the purse as he hit the ground, leaving it. No one was caught that day. No one was found that day. Prior to that, individuals were interviewed, with the exception of Adam Wright, who was recently interviewed. The defendant, Your Honor, was arrested approximately a month later on August 24th, 2022 at 525 Gridley Avenue. The defendant was arrested after a standoff with the police and SWAT had to be called out. Chemical agents were deployed in the house because the defendant was hiding in the attic in a small crawl space. By this time, the defendant had changed his appearance to try to evade capture. He had shaved his hair and his facial hair. SWAT did successfully apprehend the defendant that day, and he was interviewed. He was taken to the station and interviewed. Evidence and testimony will show that the defendant made admissions and he changed his story multiple times in this interview, Your Honor. In the beginning, he never fired a gun. That it was Brian saying Tony was the police. That he did not leave with a gun. Later, he admitted he had a gun and dropped it or lost it while he was running. He admitted using meth that day. And he said he shot Tony because they made it seem like if I didn't shoot her, they would kill me, Your Honor. The defendant said Brian, with his eyes, by the way he was looking at the defendant, told the defendant to shoot Tony. Your Honor, you will hear the 911 call. You will see the video of the individuals jumping out the balcony. You will see the photos from the scene. And you will have the medical examiner's manner and cause of death. You will also hear testimony from Angel Wright. The state is anticipating you hear testimony from Angel McClain, Ronald Crew, Ashley Broughton, Adam Wright, and Brian Fielders. Those are the individuals who were in that apartment that the state anticipates the court hearing from. Based on that evidence and testimony, Your Honor, the state is confident that you will find this defendant guilty of improperly handling a firearm in a motor vehicle that occurred on June 5th of 2022. You will find him guilty of the murder with the firearm specifications, both counts, felonious assault with a firearm specification, and tampering with evidence that occurred on July 25th of 2022. And most importantly, that these acts were not committed in self-defense. Thank you very much, Your Honor.
Thank you, Ms. Easter. Mr. Nixon, you may choose to stand if you want at the podium, or you may remain seated. It's your choice.
Grand Rising, ladies and gentlemen of the court. The case that is being presented today by the state of Ohio is not murder, nor is it felonious assault. Things aren't always what they seem. This case is a case of facts, truth, and common sense. It is not murder if it is self-defense in defense of others. It is not felonious assault if it is stand your ground. It is not my responsibility to prove defense, self-defense, or defense of others or stand your ground. It is on the state to prove it wasn't. I will ask this court to put aside emotion as much as possible with respect to the victim and pay attention to the facts and hear the truth. The truth is the truth. You can't hurt the truth. You can't help the truth. Only thing you can do is hide the truth. And the truth is the state is attempting to hide the truth. I, Quentin Valdez Nixon, am not a convicted felon. And me not being a convicted felon, I'm allowed to carry a gun. But I did not have a gun that night of this incident. I was in complete fear for my life, and through testimony from several witnesses, as well as exculpatory evidence, I will be able to prove without a reasonable doubt that my actions were justified in the provisions of law. There are questions that need to be answered. Such questions would be, what is a procedure when someone brandishes a weapon? What do you do? What is a procedure when someone puts a gun to your head? What do you do? And you don't have a gun. I have my OPATA, Ohio Peace Officer Academy certificate, which my job of choice was armed security that I did for several years. And human nature, when put in situations like that, it is either fight or flight. And I'm being persecuted because I chose to fight for my life. I chose to stand my ground. I was legally allowed to be where I was at. I could never have started the situation or the fray if I didn't have a gun. The state claims that I was high. There's no proof of me being high. The only proof of anyone being high is the person that is deceased, because it was found in the toxicology report. So through testimony from the state's witnesses, as well as my testimony of myself of the actual events that happened that night, I would be able to better prove my argument of self-defense and stand your ground. Excuse me, Your Honor. There was a room, a house, or an apartment full of people. I can't speak on what everyone was doing. I know I was legally allowed to be there by the woman who came and picked me up from my home. These same people would tell you that I'd never had a gun. These same people would tell you that I could have never just went crazy. You don't just see people with guns and go crazy. And you don't have one. That makes no sense. I did give inconsistent testimony or statement, or however you want to call it, because I was beaten by SWAT. I was barricaded in a wall, and they did throw gas and munitions, which burn your skin. I did lose consciousness when the police stumped me out. I was under duress when I gave those statements. But the truth is the truth. And through the witness's testimony that the state calls, you will be able to hear the truth. And I just ask for a fair trial and ask everything in its totality of the circumstances be taken in consideration. I'm not a violent person. I'm not a monster. This wasn't planned. This wasn't calculated. This was self-defense. I was being jumped and beaten. For what reason? Maybe it was because I was dealing with the woman whose home it was, and her ex-boyfriend was there. I don't know. You can never start the situation if you don't have a weapon. That's all, Your Honor.
Thank you. All right, Ms. Easter, you may call your first witness.
Your Honor, the state calls Angel McLean.
Oh, I'm sorry, that's right. I'm sorry, it's not Angel McLean. I'm sorry. It's Officer Hoskin. Sergeant Brooks. I apologize, Your Honor.
Come on up, Sergeant. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Go ahead and have a seat, please. Make sure the microphone light is blue, and then if you'll keep your voice up and speak into the microphone, please. All right, Mr. Villette, you may proceed.
Thank you, Your Honor. Sir, can you please state your name for the record, spell your last name?
Louis L. Brooks, Brooks.
Where do you work?
Akron Police Department,
And what do you do there?
Communications Supervisor,
And what's your current rank at the police department?
Sergeant,
And how long have you been with the Akron Police Department?
29 years.
When you first became police officer, did you go through academy?
Yes,
And are you still currently a certified recognized law enforcement officer in Ohio?
yes.
And prior to your current assignments, what other work have you done with the police department?
I was in patrol for 21 years, Detective Bureau for approximately 1 year, and currently in my current position about 7 years.
As supervisor in communications, what do you do?
I supervise the police and fire dispatchers.
Okay. And more specifically, what does that entail?
It entails scheduling their vacations, just all kind of human relations stuff. Monitoring 911 calls, making sure that they're getting answered properly.
And so if a citizen were to call in for 911, is that call recorded within the department?
Yes,
And is that a system that you have any access to?
yes,
And do you have any oversight over that system?
yes.
How so?
Complete oversight of the calls that are coming in, all the police channels.
And so when a call comes in, is that call recorded?
Yes,
And is it recorded in real time?
yes,
And is it recorded completely?
yes.
And when a call comes in, how is it tied to, say, the related incident? How do you know that in the system?
You pull up the report number and you can tell what phone it came in, if they're calling from a cell phone or,
Okay, so everything's logged under the respective report number?
yes,
And are you able to, after the fact, go back and listen to those calls?
yes,
And are those calls kept in the same state that they first come in as?
yes.
I want to take you to an incident from June 5th of 2022. It would have been report number 2022 06888. Have you had a chance to go back and see if there were any calls related to that report number?
Yes,
And were there calls?
yes,
Did you have an opportunity to go back and yourself listen to those calls?
yes, I have.
When those calls came in, did they appear to be accurately and completely recorded?
Yes,
Were they preserved in the system in accordance with standard Akron Police Department procedure?
yes, they were.
And when you reviewed those, was there any evidence of any alteration or any deletions in those calls?
No.
Your Honor, at this time, the state would move to play the respective phone calls. Let me go back. Do you recall how many calls there were?
Particularly on this one, I want to say one.
And if I were to say that there were 3 calls associated with that report, would that?
That would be accurate.
First, what will be marked as State's Exhibit 1, Your Honor. State would move to play that with court's permission.
Go ahead.
I apologize. I'm not sure why there's not volume.
Why there's what?
Not volume.
Oh, that's a great question.
It appears to be the TV. I apologize, Your Honor.
Oh, this is why. I'll turn down. Ken Masich, come out here, please. They're turned down, and every time I turn them up, they go back down.
Oh, Your Honor, it appears the screen here might allow me to do so.
Try it.
It won't main.
Okay, you guys, quick. I feel like I've been cheating on you guys. I feel like I've cheated on you. Don't divorce me. So the hearing, the preliminary hearing just started 13 minutes ago for the Kentucky judge, Kevin Mullins, he was the victim. The defendant, sorry, Morgana, cheater. So the defendant is Sheriff Stines. He's the one that shot the judge. And I was watching the hearing. Would you guys want to change lanes? Okay. Do you want to change lanes? Do you want to watch that? Because they've got a witness on the stand, an investigator. They actually show the video of it happening. I'll probably skip past that part just because it's very triggering. But you guys can, see that on your own. Yeah. Yeah. Change. All right. Then what I'm going to do is switch. Come Gosh, my hair. Y'all don't judge me because I did not wash my hair today. Um, I will go ahead and switch it, and then I will edit the title, and then probably cut this part out. So let me do that. Let's do that. We'll switch, and then we will restart the trial afterwards. I don't know how long this hearing is going to last. I don't know how many witnesses they have, but we're not dumping the case, Steph, but we are changing lanes. I knew that the hearing was going to happen, but I didn't know that it was going to be, I mean, I thought that it might just be like a, hi, how are you kind of thing. But I want to hear if they let a motive out. That's what, so let's go. We're going to change lanes. Hold on a second. Hold on a minute. Let me go over here and grab it. All right, let me share this tab. Make it bigger. Turn that one off really quickly. Okay. Yes, Steph, the sheriff and the judge thing. So I was watching it. We were streaming the trial, the Quentin Nixon trial, and then this hearing started, and it was a lot. So we'll get back to the other trial when this is over. Okay. So I'm going to restart this. Hold on a minute. So they're going to bring him in here in a second. All right. Let me put a trigger warning up. Hold on, guys. That's the sheriff right there. Okay. All right. There's no audio just yet, so I'm sorry, Steph. That's how we roll over here, right? Looks like they were called back here into the judge's chambers. They'll be back there for just a few minutes. It's not a lengthy amount of time, but I'll fast forward it. Okay, and one thing I want to say is you guys, I don't know if you see my mouse hovering right here? So this guy here in the front, behind him, I don't know who he is, but behind him is this woman that has grayish blonde hair, I think. And she has on like a pink and gray and cream colored sweater. That I am assuming, based on her reaction a while ago, that she is the judge that was shot, that is his wife, and that the two girls sitting next to her, the dark haired and then a lighter haired one, are their daughters. And that's only based solely on how they reacted a while ago when they saw this video. So here we go. Let me start it back again. Let me get to the part where the judge comes in, because they sit here for a while. Okay, here we go.
Defense is ready. Morgan District Court is now.
All right.
Morgan District Court is now in session with the Honorable Rupert Billoy. Thank you, sir. You may be seated.
Now I gotta go change the title, so I'm gonna mute myself and turn my camera off for just a quick
We'll
second.
call the case of Commonwealth versus Sean Stines, 24F 147, on for preliminary hearing. Is the Commonwealth ready?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, call your first witness.
Commonwealth's Clayton Stanton.
All right, click. Mr. Stamper, if you would. Raise your right hand for me. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You may be seated.
You state your name correctly, please?
Clayton Stanford,
And how you spell your name?
ClaytonStamper.
Joe, how are you employed?
I'm sorry.
How are you employed?
I'm a detective with the Kentucky State Police assigned to Post 13 Hazard.
How long have you been employed in that capacity?
I've been with KSP a little over 24 years, detective since 2006.
And have you, in the performance of your duties as detective with the State Police, have you investigated the death of Kevin Mullins?
Yes, sir, I did.
And can you tell us on what date that was?
It was September 19th, 2024.
In investigation of that death, were you able to determine who killed Kevin Mullins?
Yes.
And how were you able to do that?
Video surveillance footage.
And did you retrieve that video surveillance footage?
I did.
You know, at this time, the company moved to play video footage.
All right.
All right, I'll object. Approach.
Yes, approach the bench.
Okay, they're going to approach. And it's just a couple minutes. So you guys, trigger warning, trigger warning, trigger warning. This is triggering. I don't know how I feel about this. I don't know how I feel about this. Oh. Oh, God. Oof. I haven't changed the title yet. I got ready to, and then saw that they were talking, or heard that they were talking about the video. And, oh. Yeah, I can edit this video, Michelle, unless it goes past 6 hours in length. Okay,
You ready to proceed?
here we go.
Call's ready, Your Honor.
All right, go ahead.
Detective, is that a portion of the video? And will you ever identify the parties we saw in that video?
That was Sheriff Mickey Stines and Judge Kevin Mullins,
And also, who had the firearm?
Sheriff Stines.
And then, Judge was obviously in his black robe.
Yes,
Do you know what portion of the courthouse that is?
that is the judge's chambers
And where's that located at, physically located?
in the Letcher County Courthouse.
That's all I have, Your Honor.
Would you like to cross-examine the witness?
I would, Your Honor.
That was a short clip that was played there. How long do you believe that clip was?
That we just watched,
Yes, sir.
just 10 seconds, 15 seconds.
10, 15 seconds. In fact, the video that was taken in the judge's chambers between the meeting between Sheriff Stines and Judge Mullins, it's my understanding that video lasted much longer, correct?
Yes,
Okay. And have you had an opportunity to review the video
I have.
of the prior incident?
I have.
And can you describe for us what happened immediately prior to the clip that we saw?
Sheriff Stines uses his telephone to make some phone calls. He then borrows Judge Mullins' cell phone and appears to make a call on that. And that led to what you just saw.
Okay. So it's my understanding there were some people who were having a meeting with Judge Mullins prior to the sheriff's entry into the chambers. Is that correct?
Yes.
Have you identified those witnesses?
I don't know the names of them. There's about approximately 4 people in there. Then Sheriff Stines enters the judge's chambers and everybody else clears out.
You don't know their names?
Not right off, no.
Have you prepared a report? that
In-
might,
In the process, yes.
you're in the process of preparing a report,
Yes, a lot of information.
but you've not spoken to any of those witnesses?
I've not directly, but they've all been interviewed. There's recorded interviews of those people in the case.
Okay, so other officers have spoken with those 4 witnesses?
Yes.
And what is your understanding of what those 4 witnesses have said?
I don't recall.
You have no idea what they said?
No.
I want to make sure I understand, had there been a hearing previously this day in chambers?
In the courtroom?
No, in chambers.
Not that I'm aware of.
Okay. And so there's a video camera that is running in the district judge's chambers. Is that on all the time?
It's my understanding, yes.
Have you spoken with anyone about why that may be?
No. I mean, there's cameras throughout the courthouse.
Well, fair enough, but are you familiar with district judges' chambers normally, how they're set up?
No. I mean, some of them have video surveillance and some don't.
Right, but
This one does.
generally when they have surveillance, you agree with me that that is utilized when there is a proceeding going on in chambers, correct?
It could be, yes.
Okay. And I'm just asking, so this video didn't have an audio recording to it,
No,
correct?
there's no audio.
Outside of once the four people that were inside that we don't know their names, once these four people had left the chambers, were they in an area adjacent where they could hear anything that was going on?
Yes, I believe some of them did remain in the next room.
Okay. And what did they tell us?
Do what?
What did they hear?
I've not been part, I wasn't part of those interviews.
Okay, so if I'm understanding correctly, you're prepared for a preliminary hearing on a murder, and there are witnesses in an adjacent room.
I mean,
and-
they heard
Can I put
gunshots.
my question, please?
Let him ask the question.
Thank you, officer. So you are investigating a murder and testifying in a preliminary hearing, and there are witnesses who may have overheard what preceded this edited clip, yet you can't tell us today anything that they said?
I've not personally listened to those interviews. I've talked to the other officers that did those interviews.
Fair enough, and I mean, we're here at a preliminary hearing, as you know, that you can testify to hearsay. I'm asking you what they said.
They heard gunshots.
Okay, was there any statements that they overheard?
No.
Were there raised voices?
One person stated that she didn't recognize him as being Judge Mullen's voice, but heard somebody say, "Help, help."
Presumably, that will be after the firearm was drawn or shot.
Objection, Your
I would draw, Judge.
Withdraw.
So, is there any testimony that you can give us today about any statements or arguments or the content of that argument prior to the shooting?
No.
Okay. I want to ask generally, so did you process the scene? Are you the lead investigator on this case?
I am.
Okay, so as a lead investigator, I would presume that you would have secured the chambers and evidence once you arrived.
I was part of that, yes.
You were part of it, right? But you're the lead investigator, so you'd be in charge of those duties and delegating what should be done. Is that
No.
fair?
No, I don't delegate what's done.
Okay, so you're the lead investigator. What does that mean?
I'm the case officer.
Okay, so you're carrying the case. So I want to make sure I understand, had Judge Mullins been removed from chambers when you arrived?
No,
Were you able to ascertain, did he have a firearm on his person?
we did not locate one.
You did not locate one?
No, there's not one in the chambers.
Okay. And there was none on his person?
No.
Okay. All right, who was the first person to arrive on behalf of law enforcement to investigate?
They were already in the courthouse.
Fair enough, but I'm talking about in terms of people that we may see a report from or take part in this investigation. Who would be the first person?
I believe Trooper Jason Bates was the first KSP personnel on scene.
And you spoke with him
I did.
and he searched and did not locate a firearm?
No, he didn't search the scene, no.
You
His
just-
role,
Sure.
his role at that point was security of the scene.
I understand, but I'm just trying to ascertain, you said earlier that there was no firearm found. I'm
No,
wanting to know, can you tell us, was it specifically searched for a firearm?
in the judge's chambers,
Yes, sir.
there was myself, Detective Chris Collins, Detective Scott Caldwell, Detective Eric Caldwell. That's all I recall right now.
Okay, but I'm trying to understand, so who searched specifically for a firearm?
We all did,
And that was specifically something you looked for?
yes.
Fair enough, okay. Of course, your investigation, did you ascertain that prior in the day, there had been a lunch meeting between Sheriff Stines and Judge Mullins?
There was.
Pardon?
There was.
Okay. Sorry, I couldn't hear your response. I wasn't being trite. So where did this take place?
It's a restaurant called Street Side, and it's just down the street from the courthouse.
Okay. And it's my understanding there were a couple of other people who attended the luncheon?
There were several, yes.
Okay. And at some point after that, they wrapped up lunch and left, obviously, and went back to the courthouse. Are you aware of anything so far in your investigation that would tell us there was any issues at lunch between Judge
No,
Mullins and Sheriff Stines?
no.
Okay. But someone on behalf of the KSP has spoken to those witnesses?
Yes, they've all been interviewed.
And there was nothing unusual that had arisen during that luncheon?
I was told that the judge made a statement to Mickey about, do we need to meet private in my chambers? That's all I was told.
Do you know the context of
I do
what
not.
the conversation was before that they would need to discuss in chambers?
I do not.
So it's my understanding that in the larger portion of the video that we haven't had access to, that there is a point when Sheriff Stines asked for to see the telephone of Judge Mullins.
Yes.
Is that a yes?
Yes.
Yes, okay. And I would presume that you and the other officers you mentioned, when you secured the scene, that you secured those phones as well, is that correct?
Yes.
And have you reviewed both of those phones?
They're currently at the forensic lab at this time being downloaded. I have had discussions with the people at the lab regarding the downloads.
And those are a couple of other questions that I was going to ask you, but my original question was, have you reviewed or are you aware of the content of the phones?
I've not personally seen it because I've not received those reports yet.
Okay, again, based upon your conversations with the officers, are you aware of any recent content that was up and could have been relevant at the time of their discussion?
I was told that Sheriff Stines had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
So, have you obtained the phone records from Judge Mullins' phone?
I don't have those in my possession yet, no.
Okay, have you issued a search
Yeah,
warrant for them?
yes.
Okay. And have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins' phone?
Yes, I
Okay.
believe so, yes.
So that number had been called from Judge Mullins' phone?
Yes.
Is that correct?
Yes.
Okay. So we don't have a viewing of what transpired during that exchange of phones. But based upon your review of those moments prior to, when Sheriff Stines observes that cell phone, was he previously seated?
Yes.
Okay, so in the clip we saw, he was standing the entire time.
He was seated in front of the judge's desk.
And he looks at the cell phone. Can you describe his reaction in the video that we haven't seen?
Whose reaction?
Well, the sheriff.
You can't see his face in the video.
Okay. But is it clear that, does it appear to you that, let me rephrase this. Did he stand up after
Yes.
looking at the phone?
He stood up.
And how long after he looked at the cell phone and stood up did this occur that you played?
Just seconds.
Did you make the decision as on edits today for what you were going to present?
Do
In
what?
terms of, did you make the edit or determine
No,
which portion of the video we were going to see today?
no, sir, I did not.
Both cell phones have been sent to the Kentucky State Police Forensic
Yes,
Team, is that correct?
yes.
Have you gotten any early report on what was found?
No.
Were both phones still on the desk when you
The
arrived?
the judge's phone was on the desk. Sheriff Stein's phone was on his person.
Okay, so, are there photographs of, was the phone locked at that point, or was it still open?
With both of you asking about both of them, or?
Well, first, let's talk about, that's fair. First, I'm talking about Judge Mullins, since it was the one that was still on the desk and presumably, nobody touched it prior to you securing it, correct?
No, no.
So, yeah, so would like to know about that. Have you ascertained what was currently open on that cell phone?
No, I don't know at this point, no.
You don't know.
No.
Do you think that would be, important to learn?
I hope to learn that when the report's ready, yes.
But as of today, you can't tell us
No.
what was currently open on the judge's phone.
No, sir.
Did you conduct an interview with Sheriff Stein's daughter?
I did not, but she has been interviewed.
Are you aware of who was present when she was interviewed?
Lieutenant Randy Combs and Detective Anthony Trotter.
She was interviewed with or without her parent?
With,
So her parent was present at the time you interviewed her?
yes, I believe. I wasn't there, but yes, I think so.
And law enforcement has not spoken to her without her parent present?
Not that I'm aware of.
Did the Kentucky State Police obtain her phone?
No,
You intend to obtain records for her cell phone number?
possibly, yes.
Do you believe that will be soon that you'll do that?
Could be, yes.
Had you already intended to do that, or did you just respond to my question?
Well, the call should be on the judge's records too.
Well, I understand.
And
but-
she's made statements about what occurred during those conversations.
I understand that, but I would presume that, have you ascertained whether Judge Mullins also had apps that stand outside of phone records?
I've not received those records yet. I don't know what's on the
Well,
phone.
fair enough, but I mean, did you look at the phone? Did it appear there were apps on it?
I'm not the person that's qualified to look through the phone.
Okay, but you're familiar with cell phones. They can host other forms of communication. Yes, sir.
What's the objection?
He didn't ask an answer, Your Honor. He's asked a question, I think, about 4 or 5 different ways. The officer, the detective repeatedly said that he does not have a report with phones, he's not looking at the phone. He can't testify that matter.
I'll let him ask the question, and what he can only testify what he has personal knowledge about.
Absolutely, yes, sir. Thank you.
Right.
So you're aware that phones can be used for apps such as Facebook?
Yes,
Okay. And that is not something that is captured by cell phone records. You would agree with me?
I agree.
So in light of that, although the records may be mutually the same, right, the same between Judge Mullins' phone and the sheriff's daughter, do you believe that you could also ascertain other information from the cell phone app content?
Are you asking what apps are on the phone?
Yes. Well, that was my original question.
I don't know
thought you did
without, I've not received that report yet. I don't know what apps he had downloaded on the phone.
If he has social media apps, do you intend to?
That could lead to additional search warrants, yes.
If you would, officer, please let me finish before you move forward, and I'll try to slow down a little bit as well, okay?
Sure.
Thank you, Trooper. Have you determined whether there were any previous issues, personal or professional, between Sheriff Stines and Judge Mullins?
I've heard things.
What have you heard?
Just that, of this regarding the lawsuit that the Letcher County Sheriff's Office is currently involved with.
Okay. The lawsuit that involved ultimately a criminal conviction of a deputy for sexual behavior in the judge's chambers, is that the one you're referring to?
Yes.
Okay, and the subject matter of that lawsuit, the chambers area, that's the same chambers in which this occurred, is that correct?
I'm not familiar with the details of that case that the lawsuit resulted from.
Okay. Are you aware of any criminal reports that Sheriff Stines had made of Judge Mullins prior to this day?
No.
Did you personally observe Sheriff Stines following this video?
Did I personally observe him? What?
Did you meet with him? Did you talk to him after?
He was in custody when I arrived at the courthouse that afternoon.
And at some point, did you draw any observation about his demeanor?
He was mostly calm, I thought. I mean, I talked to him, but he didn't say nothing about why this had happened. But he was calm. He was kind of afraid that basically all he said was, "Treat me fair." That's basically the comments he made.
Okay. Did he also make a statement about, I didn't see it in the citation, you're somewhere along the line I saw a statement being attributed to him about.
Okay, I hate to pause it, but also Steph and Kel, I kind of think, I don't know that I don't know, but I feel like he's not purposefully not being forthcoming. I think this murder literally happened like 2 weeks ago. So they're like headlong into, like, they probably don't have a lot of stuff back yet. You know what I mean? Also, Steph said allegedly, I think he's just dumb. But also, he probably feels like he's stuck between a rock and a hard place. You know? Hey, Tanika. Good to see you. I think he probably feels like he's stuck between a rock and a hard place. Now, I don't know if he knows both the judge and the sheriff personally or not, but I know from what I've heard on the YouTubes and other places that the judge and the sheriff knew one another, obviously, but they have a lot of mutual friends, and I think everybody's just shell-shocked still, so. Right, Steph. That's why I'm saying he's a state police officer. So, I don't know. He said he was, worked from the Hazard, Kentucky Post. So, I don't know how close that is to Whitesburg, but I don't know if it's close or not close. If it's close, then they probably know each other. If it's not, then they probably don't. But still, he's probably like, here I am investigating a judge and a sheriff, and feels weird, you know? No, it's not his boss. No. But, on like a work level, I just don't know what he knows, you know?
Protecting his family.
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, they're trying to kidnap my wife and kid.
Now, have you ascertained any evidence that this shooting was pre-planned?
No, not at this time.
And would you agree that from what we've seen so far, from the evidence you've seen so far, the shooting was a reaction to what was on that cell phone in that moment? Is that accurate?
Objection, Your Honor. All speculation outside of his scope of expertise.
Your Honor, I believe that if he has formed an opinion about the investigation up to this point, especially at a preliminary hearing, we can speculate on that, Judge.
Or sustained.
Sure. So, is there anything other than the content of the phone that this video will reveal to us about why this took place?
No.
Does it appear that this took place as a reaction to what was happening in the chambers at that point?
I can say it occurred after a phone call was made. I don't know what was said or nothing like that, but
Fair enough, and I'm not asking you the content of any of that, but at this point, is it your theory that whatever that content was in the discussion was the impetus of the shooting?
it could be, but I don't know that for a fact.
Okay. Do you have any evidence up until this point that you have developed that would demonstrate that it was not as a reaction to what was on the phone?
No,
None whatsoever?
no.
Okay. Here's if I had just one moment of control. Did you attempt to speak to Sheriff Stines at the Leslie County Jail after the incident?
No,
Did anyone from your agency attempt to interview him?
not to my knowledge, no.
And at that point, had he asserted his right to an attorney or anything?
No,
But nobody went back to try to talk to him or do an interview?
no.
I think I have one other question. In addition to cell phones that we discussed, the cell phone of Sheriff Stines and the cell phone that you found of Judge Mullins, were there additional phones that you were able to obtain?
There was one other phone that's currently being examined, and the basic reason it was seized was there was a text conversation between Sheriff Stines and some of his employees with the sheriff's office.
Okay, and that was an additional phone of Sheriff Stines?
It was a phone of, I guess she's the, I don't know what her title is, but she's employed. She's not sworn. She's employed by the Letcher County Sheriff's Office. And she voluntarily gave her phone to the person that interviewed her.
Okay, and just out of curiosity, what, could you explain why that was relevant or germane to your investigation?
I didn't conduct that interview, but it was, I guess it was regarding the dinner at Streetside and things that led up to the shooting. But I don't have those results either, so I don't know exactly what was said.
Correct me if I'm wrong, I thought when we discussed that earlier that you indicated there was no evidence that the conversations at the lunch.
I haven't seen those conversations yet. I've not received the downloads from the phone.
Right, but I asked you if you're aware of any information that could have been gleaned from witnesses at that meeting, and as I recall, you said no, but there is some information that something was discussed at this lunch. Is that correct?
I don't know what was discussed at lunch.
I understand, but you obtained this lady that we don't know her name, you obtained her phone in an effort or based on a belief that she would be able to demonstrate what was said at lunch. So you would agree with me, you believe that there is a witness or information that may have popped up at lunch.
There's a recorded interview with her in the case, and I'm yet to receive the downloads of the phone, so I don't know what they contain.
Okay, has that phone been sent to the
It is.
forensic examination as well?
Yes.
All right, thank you. Also, that's all I have. Thank you.
Redirect. Questions? Has Judge Mullins, he sent to medical examiner's office for an autopsy?
He was.
Have you received that report yet?
No.
Have you had an informal conversation with him regarding his cause of death?
Yes.
And what was that?
Multiple gunshot wounds.
The video we showed earlier, that a true and accurate clip copy of what you received?
Yes.
Councilman introduce Council Exhibit number 1, Your Honor.
Any objection?
Your Honor, I'd ask, of course, all we saw today was the clip, but I asked it be admitted in its entirety, Your Honor. Is it exhibit?
You want to respond to that?
Did not know. Only thing preliminary hearing is required for is probable cause. This statute is probable cause. I think the entire clip is outside the purview of these proceedings today.
Yeah, I think if you're going to want to see the whole video, you should have objected earlier. I'll admit the short clip. Yeah. I have the clerk enter that as exhibit number 1.
And Detective, this is an ongoing investigation.
Yes, it is.
And as this ongoing investigation proceeds, you will be obviously interviewing more people if necessary, submitting more evidence to the lab.
Yes.
That's all I have, Your Honor.
Recross. All right. Any other witnesses for the Commonwealth?
No, Your Honor.
All right. You may step down. Any witnesses for the defendant? I'll find probable cause and bind this case over the grand jury. Anything else? Anything else before we adjourn court?
There's no, we're not allowed to sum up, Judge, what.
Oh, if you want to make an argument, sure.
It seems like I may change your mind, Judge.
It is a probable cause hearing, so, but yes.
I understand.
Take your best shot.
Thank you, Your Honor. Well, so, murder under our statute, as the court knows, and I'm not telling you anything you don't know, but if there is an issue as to extreme emotional disturbance, then there has to be some evidence that would rebut that. And specifically, when I asked the witness today if there was any evidence to rebut that this occurred as a direct result in the moment of this observation in the phone, they have none at this point. And I give it's just probable cause, but I think they've established probable cause for manslaughter first, but not murder. Because I've heard nothing that indicates that this is not, an example of an extreme emotional disturbance relative to the phone. At any rate, Judge, respectfully, I understand the court's previous ruling, but I did want to address that with you.
No, that's fine. Let
Thank you, Your Honor.
the Commonwealth respond.
Thank you, Your Honor. Chairman Marshall determines is a defense. There's not been a defense presented here to this court today. The evidence presented to this court today is that the judge was intentionally shot and killed, shot multiple times by the sheriff, and there's probable cause to find us the grand jury murder charge.
Yeah, I agree. There's probable cause to proceed as murder.
Yes, sir.
All right. Anything else before we adjourn court today?
Your Honor, in terms of, we'd like to discuss, if we could, lodging from here, mortgage transport. Is it the court's intention to have him take, and I don't want to discuss that potentially publicly, Your Honor?
I'm not sure I can make that, help you on that.
Yes, Your Honor, so,
I mean, we could, you're welcome to stay after court and discuss that, but I'm not sure I can tell the.
yes, sir, so the transport order that was entered that will direct Sheriff Stines to go back to where he came from, Judge, is that fair?
Let's adjourn court and we'll talk about that.
Yes, sir.
I don't know that I can change where he's going to be at.
I understand, yes, sir.
We can discuss it. All right?
Thanks, sir.
All right, court's adjourned.
Yes, sir.
Still so confused. Hey, Mickey. Mickey says that's his daughter seen right behind his shoulder to the left. And I agree with Steph. She looks, older. I mean, Tanika says, do we think the sheriff has a competency issue? I mean, do we? I don't know. They brought up the thing that he said something about they're trying to kidnap my daughter and my wife. The judge is going to kidnap? Unless it was a situation where maybe the phone calls or whatever it was. What am I trying to say? I want to say this without just speculating or just theorizing. Could it be a situation where, if the judge was doing something he shouldn't have been doing with the daughter of the sheriff, and the sheriff brings it up to him, something was said at lunch, somebody overheard something, and he says something to the investigator about, somebody said that he said he was going to kidnap the wife and the daughter. You know what I'm saying? Like, did the judge, kind of say that in not so many words? to, you know, I don't know. I'm really confused. Yeah, Miss King, we still don't know. All we know is that he said that this was a probable cause hearing, and there was probable cause. So, said that it would go before a grand jury. So, anyway, I don't know. Right, Morgana. Morgana says, did he mean literal kidnapping or like mental kidnapping? Do you know what I mean? Yes, Cooter. Seems very movies, though. Yeah. But or if a conversation to someone who was in the vicinity during the lunch that they were talking about or whatever, was it multiple people at the lunch or just the lawyer and the judge? I don't know. I don't know. I have no idea. So confusing. But definitely something to keep our eyes out for updates as things occur, right? Okay, they did say multiple people at the lunch. So if it was like a work lunch, like, hey, everybody, it's lunchtime, let's go meet at blah, 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 you know, if somebody was whispering and said, oh, well, you know, so-and-so's on to you, buddy. And he's like, well, if so-and-so says something, I'll take them and hide them somewhere. You know what I mean? Just something like that. Just whispery things. That's one thing I don't. I don't know. That's tough. Cooter says it's so weird that they didn't even interview him and take a statement. That's sus to me. Apparently, there's a press conference about P. Diddy right now. I don't know. But, you guys, I'm going to end this live stream. And then I'm going to come back and start the trial that we were watching back. Okay? And then I'm going to edit this video to cut all the trial stuff out and let this just be the hearing stream. So, and we'll start the trial back. We'll skip through the stuff, maybe like 1.25 through some of the stuff we've already heard, just to kind of keep it all together. Because honest to goodness, I had like I said, I was cheating on y'all. Had this playing, or the trial playing, while I was over here listening to this hearing, and that's what made me jump in and be like, yo, we're gonna change lanes. So, but yes, Tanika, the storm. Oh, hey, Laura, good to see you, Miss. That's her little peep-eye face. Peep-eye. All right, I want to scooch out of here. It is 2:10. Let me get the stream rescheduled, and we'll plan on 2:45, 3, something like that. Okay. Mickey said, yeah, she's 17. Okay, well, 17, I don't know. I mean, She looks like she's in college. I don't, maybe people were maybe, and I don't want to say the judge because I don't want to put that on a man if that's not true. You know what I'm saying? I don't know. We're just going to have to keep our ears open for, um, wait for updates. That investigator, Mickey, I think he said kidnap. "17, and if they've known each other personally for multiple years." Yeah, I don't know. Spence says, how can they go to trial without all the evidence available? Well, it'll be quite a while before they actually go to trial. So they'll have the evidence by the time they're ready to go to trial. So this just happened last month. So that's why they don't have reports and phone dumps and all that kind of stuff yet. But, all right, you guys, I'm going to go schedule the other one, and we'll see you over there momentarily. I'll give it about 30-45 minutes, and then we'll get back started over there. All right. Thanks for hanging out and hanging in with me. You guys hang in there so good, like a hair and a biscuit. All right. I'll see you guys in just a bit. All right. Make sure to hit that thumbs up button before you leave, and make sure your notifications are turned on. All right. Love you guys. Bye.